This Guy's Garage. Like and subscribe.
And I believe the honourable member for Medicine Hat, Carson Warner, is standing on a point of privilege.
Yes, thank you, Mr. Speaker. I'm rising with respect to the notice of a question of privilege, which I provided to you under Standing Order 48 concerning the third and final report of the Special Joint Committee on the Declaration of Emergency, which was tabled in the House of Commons earlier today. In brief, when the member from Eglinton Lawrence, then the Minister of Public Safety, appeared before the committee on April 26th of 2022, he made repeated assertions that the NDP Liberal government invoked the Emergencies Act at the request of law enforcement. This now infamous claim by the former minister, made at the committee table, went viral.
I believe a point of order, the honourable member for New Westminster Burnaby.
Thank you, Mr. Speaker. It's always important to question a privilege. It's important to be factually correct. The minister wouldn't have referred to the NDP Liberal government, and so I would ask through you that the member respect the rules around a question of privilege and stick with the facts.
I appreciate the honourable member's intervention on that, and I will again just remind those who are presenting points of privilege here to be factual and, of course, as efficient as they can with the time they have before them, and stick to the facts themselves. The honourable member for Medicine Hat, Carson Warner.
Thank you, Speaker. This now infamous claim by the former minister, made at the committee table, went viral as police officer after police officer and official after official denied it before the committee, the Standing Committee on Procedure and House Affairs, and the Public Order Emergency Commission. Documentary evidence further substantiated just how wrong the former minister's claim was. With all reports from all three bodies now formally before the House in the present session, the House is seized with irreconcilable claims for which the air must be cleared. As you know, it is a contempt to mislead the House of Commons or any of its committees. I will therefore argue that the member from Eglinton Lawrence deliberately misled the Special Joint Committee, giving rise to a prima facie contempt. The committee's third report details, in the first paragraph of the justification section of Chapter 7, under the invocation of the Emergencies Act, the former minister's evidence to the committee on April 26 of 2022, and I quote, "Some witnesses before the committee cited the public safety concerns as justification for a cabinet's decision to invoke the Emergencies Act. For instance, the former minister told the committee that the federal government received advice that law enforcement needed the Emergencies Act to be sure that they would resolve, for example, ambiguities around those who were staying close to ports of entry. He reiterated that we invoked the Act because it was the advice of nonpartisan professional law enforcement that existing authorities were ineffective at the time to restore public safety," end of quote. For good measure, Mr. Speaker, the former minister's other comments to the committee that night include the following, and I quote, "The government remained engaged with further enforcement throughout to ensure that they had the support and the resources they needed. However, when efforts using existing authorities proved ineffective, the advice we received was to invoke the Emergencies Act," end of quote. He went on to say, and I quote, "The advice we were getting was that law enforcement needed the Emergencies Act," end of quote. He also was stated as saying, and I quote, "As we took our decision in what we could do to respond, we were following the advice of various levels of law enforcement, including the RCMP and commissioners," end of quote. Now that last quote is particularly important, bearing in mind what the committee reported, beginning at the 10th paragraph of the section on cooperation among different levels of policing found in Chapter 5, Police Response to the Freedom Convoy, and I quote from that report, "There is evidence to suggest that police leadership had exhausted all available tools to bring the protests and blockades to their conclusion when the federal government decided to invoke the Emergencies Act. At the Public Order Emergency Commission, a 14th of February 2022 email from then Commissioner of the RCMP, Brenda Luckie, to the Chief of Staff to the former minister stated, and I quote, "This said, I am of the view that we have not yet exhausted all available tools that are available through the existing legislation. There are circumstances where charges could be laid under existing authorities. for various criminal code offences occurring right now in the context of the protest. The Ontario Provincial Emergencies Act, just enacted, will also help in providing additional deterrent tools to our existing toolbox. These existing tools are considered in our existing plans and will be used in the due course as necessary. End of quote. I want to pause here for a moment, Speaker, to note three things. First, on September the 22nd, 2022, the committee adopted a motion with a view to achieving efficiencies in its own proceedings to quote the report, deem the evidence, including testimony and documents received by and published on the websites of the standing committees of the House of Commons and the Public Order Emergency Commission in relation to the February 2022 public order emergency and matters consequential to it to have been received by this committee and may have been used in its reports. End of quote. Secondly, as we know from the Relu Commission records, the former minister's chief of staff forwarded the RCMP commissioner's message directly to the then minister. The email is Relu Commission document Sierra Sierra Mike SSM NSC CAN 0000228. And thirdly, Commissioner Lucky's statement about not exhausting all available tools was actually emboldened to attract the attention of the minister's eye with red lettering. So it's clear, Mr. Speaker, that the member from Eglinton Lawrence was put on clear notice that invoking the Emergencies Act was not the RCMP's advice, in sharp contrast to what he had claimed at the committee table. Now, going back to the third report, picking up 4 paragraphs later, we read, and I quote, then Ottawa Police Chief Peter Sully told the committee that the Ottawa Police Service had a plan ready to clear downtown Ottawa and that the Ottawa Police Service maintained control of the plan during his tenure as the Chief of Police, end of quote. Now, his tenure ended the day after the Emergencies Act was invoked. Mr. Sully testified before the committee on October 6, 2022, and is quoted on page 3 of the evidence saying, and I quote, there were no explicit conversations that I had with other levels of government regarding declarations of the Emergencies Act at all 3 levels, end quote. He then immediately clarified this, adding, and I quote, we did have conversations with the City of Ottawa around their emergency, but not the other 2 levels of government, end quote. Other witnesses before the Special Joint Committee also testified that they had not requested the invocation of the Emergencies Act. Then, RCP Commissioner Brenda Lucki is quoted on page 10 of the evidence for May 10th of 2022 saying, and I quote, no, there was never a question of requesting the Emergencies Act, end of quote. When pressed to confirm that statement, if she ever asked for the invocation of the Act, she firmly answered, no, end of quote. The then Emergency Preparedness Minister, now the Minister of National Defence, testified on June 14th of 2022 at pages 22 and 23 of the evidence that he had not heard any advice or request from the police asking for the invocation of the Emergencies Act, adding, and I quote, quite frankly, I would have been surprised, quite surprised, if the police had actually made a policy recommendation or asked for any legislative authority, end of quote. On October 26, 2022, then Ottawa Mayor Jim Watson confirmed at page 14 of the evidence that he had not sought any emergency declarations. On November 3rd of 2022, Ontario Police Commissioner Tom Korik confirmed at page 17 of the evidence, and I quote, I can tell you that I am telling you the absolute truth, sir. At no point did I provide or request that Emergencies Act be invoked, end of quote. He then added, and I quote again, I did not provide any advice of that nature, nor am I aware of anyone from my legal team providing such advice, end of quote. Those statements alone, Mr. Speaker, show that there was irreconcilable evidence before the committee, which has now been reported to this House. But the concern just doesn't stop there. In parallel to the Special Joint Committee's work, our Procedure and House Affairs Committee was conducting its own study of security arrangements on or near Parliament Hill, hearing from a number of pertinent policing and security witnesses who appeared in the aftermath of the former minister's famous claim. The evidence which it heard was reported to the House in that committee's 19th report, tabled on December 14th of 2022. Firstly, on page 13, we read the former minister's own take, and I quote, "During the appearance by the then Ministers of Public Services and Procurement and Public Safety, some members of the committee asked questions about the invocation of the Emergencies Act. In particular, it was asked which police agency asked for the Emergencies Act to be invoked. In response, the member for Eglinton Lawrence stated that there was a very strong consensus among law enforcement that the Emergencies Act was necessary, is stipulated in the letter from the Canadian Association of Chiefs of Police." End of quote. Then, turning to page 23 of the 19th report, we see, and I quote, "When asked about the invocation of the Emergencies Act by the federal government, then interim Ottawa Police Chief Steve Bell stated that the Ottawa Police Service, had conversations with its partners and political ministries, but did not directly request that the Act be invoked." Chief Bell later testified before the Special Joint Committee on November 3rd of 2022 at page 2 of the evidence that, and I quote, "No, we never made a direct request for the invocation of the Act." End of quote. Later in that same meeting, at page 9, he confirmed, and I quote again, "That's correct. There was no direct request made from the Ottawa Police Service." End of quote. Now let's go back to the Procedure and House Affairs Committee's 19th report. We read on page 26, and I quote, "Asked whether the service of the police service of Gatineau was able to manage the disruptions in Gatineau caused by the Freedom Convoy, Service Director Luc Baudoin indicated that it was able to do so, in particular thanks to the collaboration of its partners and the Coordination Center." End of quote. Moving to page 29, we learn, and I quote, "When asked if the Parliamentary Protective Service had requested the invocation of the Emergencies Act on February of 2022, Service Acting Director Superintendent Larry Brookson answered no. He noted that there was no benefit whatsoever in the invocation of the Emergencies Act for PPS because it is not a policing organization, so it received no additional powers through the Act." End of quote. I would pause here, Mr. Speaker, to add that Superintendent Brookson confirmed this evidence for the Special Joint Committee during his appearance there on September the 29th of 2022 at page 10 of the evidence. Mr. Slowly, the former Ottawa Police Chief, had also appeared before the Procedure and House Affairs Committee, which reported at page 37, and I quote, "He did not ask the federal government to invoke the Emergencies Act. He was not aware of anyone making that request within the Ottawa Police Service." End of quote. The then city manager of the City of Ottawa, Steve Kanellakis, was also a witness. And the 19th report, page 48, states, and I quote, "Mr. Kanellakis was asked by the committee whether the Ottawa Police Service had requested the invocation of the Emergencies Act. In response, he stated that he was not aware of any such request." End of quote. Mr. Kanellakis also said in his opening statement to the Special Joint Committee on October 26, 2022, at page 3 of the evidence, and I quote, "To my knowledge, the city never requested the invocation of the Act." End of quote. Next, Speaker, let's turn to the report of the Public Order Emergency Commission, which was tabled at in this House on February 17th, 2023, as sessional paper number 8530-441-17. First, on page 115 of Volume 1, Commissioner Rouleau wrote, and I quote, "A question that arose during the Commission's hearings was whether Cabinet was advised of Commissioner Lucky's view that not all existing tools had yet been exhausted in Ottawa. She had expressed this view to the former Minister's Chief of Staff less than an hour before Cabinet meeting began, but this was not passed on to Cabinet." End of quote. Later, the Commissioner expanded upon this at page 92 of Volume 3. A question that arose during the Commission's hearings was whether Cabinet was advised of Commissioner Lucky's view that not all existing tools had yet been exhausted in Ottawa. Less than an hour before the Cabinet meeting began, Commissioner Lucky responded to an email request from the former Minister's Chief of Staff, Mike Jones, for a list of emergency measures that might assist law enforcement in bringing the protests under control. Commissioner Lucky suggested a number of tools, but added that, in her view, all of the tools available through existing legislation had not yet been exhausted. She noted that there were instances where charges could be laid under the criminal code, and that Ottawa's recent declaration of emergency would also help in providing additional tools. Mr. Jones forwarded Commissioner Lucky's email to the former minister and then Deputy Minister of Public Safety, Deputy Minister to Public Safety, Robert Stewart, half an hour before the Cabinet meeting began. The comment about the sufficiency of existing tools was not incorporated into the speaking notes that Commissioner Lucky sent to the former minister. And the then National Security and Intelligence Advisor to the Prime Minister, Jody Thomas, a few minutes before the start of the meeting. End of quote from the Commissioner's notes. In addition to these three reports, Mr. Speaker, the former minister testified to the Special Joint Committee is also contradicted by the government's response to order paper question number 613, signed by the then minister's parliamentary secretary. Through this written question, the government was asked, and I quote, "With regard to the government's invocation of the Emergencies Act earlier this year, did any police force make a request for the Act to be invoked? And if so, what are the specific details of any such requests, including which police forces submitted that request, and on what date each such request was received by the government?" End of quote. The then Parliamentary Secretary response danced around the heart of the question, but she nevertheless answered, and I quote, "The RCMP did not request for the Act to be invoked." End of quote. And she reiterated that quote with again, and I quote, "With regard to the RCMP, the Royal Canadian Mounted Police did not make a request for the Act to be invoked." End of quote. All in all, Mr. Speaker, the former minister's claim to the Special Joint Committee found in its report, which is now before the House, has been flatly contradicted by all other evidence on the question before the House. Now, the House of Commons Procedure and Practices, 3rd edition, at page 81, provides a list of established grounds for contempt, including, and I quote, "deliberately attempting to mislead the House or committee by way of a statement, evidence, or petition." End of quote. This point is reiterated again at page 112. For its part, United Kingdom House of Commons Committee on Privileges has also recently considered the matter of a minister misleading Parliament. That committee's 5th report, tabled in June of 2023, notes at paragraph 6 that, and I quote, "misleading intentionally or recklessly, refusing to answer legitimate questions, or failing to correct misleading statements impedes or frustrates the functioning of the House and is a contempt." End of quote. The importance of accurate information being provided to Parliament has been underscored in a number of rulings in this House, including your predecessor on March 3rd of 2014 at page 3430 of the debates. It states, and I quote, "This incident highlights the primordial importance of accuracy and truthfulness in our deliberations. All members bear responsibility, individually and collectively, to select the words they use very carefully and to be ever mindful of the serious consequences that can result when this responsibility is forgotten." End of quote. The United Kingdom Privileges Committee, meanwhile, explained at paragraph 8 of its 4th report, tabled in March of 2023, that, and I quote, "the expectation is that when the House hears from ministers, what it hears is the truth as far as the minister knows it. The House considers legislation and scrutinizes government activity on the basis that what it is told is accurate. Parliament expects and requires proactive candor and transparency. This is what is necessary for the House to do its job properly. If a minister makes an inadvertent error, they are expected to correct it at the earliest opportunity. Mistakes inevitably happen, and corrections are made routinely. The more important the issue, the more seriously the House will take any questions of misleading." End of quote. There is a well-established test for determining whether deliberately misleading information has been provided, which, for example, you explained in the February 15th, 2024 ruling at page 21158 of the debates, and I quote, "It must be proven that the statement was misleading. It must be established that when making a statement, the member knew it to be incorrect, and finally, it must be demonstrated that the member intended to mislead the House." End of quote. In the circumstances, Mr. Speaker, I would respectfully submit that all three branches of this test can be made out. First, the overwhelming body of evidence, in fact, basically every source of evidence other than the former minister himself, which I have already quoted, contradicts the former minister. There can be no reasonable conclusion other than the fact that the former minister's statement to committee was misleading. Secondly, the email from the then RCMP commissioner to the former minister's chief of staff, who in turn forwarded it to his boss, makes it quite clear that the former minister was on notice of the actual opinion of the country's top cop. In the face of it, how could he plausibly claim that law enforcement actually made the request? And thirdly, Mr. Speaker, the context of the former minister's comment and tried to manage concerns regarding an extraordinary assertion of legal powers by the federal cabinet in response to a protest against its policies is one which goes to explain the likely intention behind it, to syndicate the responsibilities for such a controversial decision onto the shoulders of non-political institutions like the police and away from the political actors who actually took the decision. In any event, intention is not something which I would respectfully submit requires, at this stage, ironclad proof, like a confession. Indeed, the Procedure and House Affairs Committee, at paragraph 15 of its 50th report, presented in March of 2002, explicitly acknowledges that intention may well be a matter for committee investigation. And I quote that particular report. As the then Clerk of the House, William Corbett, explained to the committee, "It is not uncommon for inaccurate statements to be made in the course of debate or question period in the House. This issue is whether the statements were made deliberately with the intent of misleading the House or its members. In the case where a member later admits to having knowingly provided false information, as in the Profomo case, the issue of intent is clear. In the absence of such an admission, however, it rests with the committee to examine all of the circumstances and determine whether the evidence demonstrates an intention to mislead." End of quote. The Procedure and House Affairs Committee continued in the same vein at paragraph 39 of the same report, noting that at times inferences must be drawn to establish intent. And I quote that report again. "Intent is always a different element to establish in the absence of admission or confession. It is necessary to carefully review the context surrounding the incident involved and to attempt to draw inferences based on the nature of the circumstances. Any findings must, however, be grounded on facts and have an evidentiary basis." End of quote. At Westminster, meanwhile, the Privileges Committee, in its fourth report, wrote at paragraph 6, and I quote from that particular report, "If a statement was misleading, we will consider whether that was inadvertent, reckless, or intentional. If we conclude that it was in any way reckless or intentional, we will consider what sanction to recommend to the House. It will be for the House to decide whether to accept or reject our conclusions and recommendations." End of quote. It might also be worth noting here, Mr. Speaker, citing the related footnote in footnote 4 of that report, and I quote, "We emphasize that the committee is not a court of law. It is a select committee of Parliament, and its processes are parliamentary rather than forensic. The committee will adopt plain English definitions of key concepts as used in a parliamentary context." End of quote. The Parliamentary Privilege in Canada, second edition at page 234, explains, and I quote, "Before the House will be permitted by the Speaker to embark on a debate in such circumstances, it must be demonstrated that a member of the House of Commons was intentionally misled, or an admission of the facts that leads naturally to the conclusion that a member was intentionally misled." End of quote. The long list of contradictory evidence, which I suggest lead naturally to the very strong inference, is not the conclusion that the Special Joint Committee was intentionally, I'll read that again, Speaker. The long list of contradictory evidence would, I suggest, lead naturally to the very strong inference, if not the conclusion, that the Special Joint Committee was intentionally misled. Next, Speaker, I wish to address another matter concerning this question of privilege, namely the requirement to rise in a timely manner. On first blush, raising a concern about something which was said over 31 months ago would not be considered timely. However, since it happened in a committee, the clock only started from the moment the third report was tabled in the House, which was this morning. It would have been premature to have raised this concern any sooner. As Mr. Speaker Reagan said on September 27th of 2016 at page 5175 of the debates, and I quote, "The Speaker cannot pass judgment on matters that are not properly before the House. The authority of the Speaker is limited to studying evidence before the House, such as statements made in the House or matters detailed in reports from committees, and not evidence gleaned from other sources." End of quote. Your immediate predecessor held on May 11th of 2021 at page 7023 of the debates, and I quote, "There is no precedent where the chair has used testimony from a committee without there being a report on the subject." End of quote. This rationale was more fully elaborated by Speaker Milliken on February 10th of 2011 at page 8030 in a comment quite relevant to the present case, given the former minister's wild claim became a matter of considerable discussion on the floor of the House. And I quote from that particular ruling. "The chair was limited in its ability to act on the full range of that review, since much of the proceedings referred to in member submissions were never officially placed in the hands of the House. The Parliamentary Secretary to the Government House Leader was not mistaken in his assertion that any and all statements made in committee, even when there have been repeated verbatim in the House, remain the business of the committee until such time as it elects to report them officially to the House. It may sound overly technical, but the reality is that when adjudicating cases of this kind, the chair is obligated to reference material fully and properly before the House." End of quote. But now, the information is fully before the House and squarely before the House in the form of the third report, the Procedure and House Affairs Committee's 19th report, the Reload Commission's report, as well as the order paper question response, which I quoted. We are now faced with the concern expressed by one of your predecessors on March 3rd of 2014 at page 3430 of the debates, and I quote, "At the same time, the fact remains that the House continues to be seized of completely contradictory statements. This is a difficult position in which to leave members, who must be able to depend on the integrity of the information with which they are provided to perform their parliamentary duties." End of quote. In that case, the chair found a prima facie case of privilege, just as Speaker Milliken did on February 1st of 2002 at page 8581 of the debates when he said, and I quote, "The authorities are consistent about the need for clarity in our proceedings and about the need to ensure the integrity of the information provided by the government to the House. Furthermore, in this case, as honourable members have pointed out, integrity of information is of paramount importance, since it directly concerns the rules of engagement for Canadian troops involved in the conflict in Afghanistan, a principle that goes to the very heart of Canada's participation in the war against terrorism. In deciding on alleged questions of privilege, it is relatively infrequent for the chair to find prima facie privilege. It is more likely that the Speaker will characterize the situation as a dispute as to facts. But in the case before us, there appears to be, in my opinion, no dispute as to the facts. I believe that both the Minister and the honourable members recognize that the two versions of events have been presented to the House. On the basis of the arguments presented by honourable members and in view of the gravity of the matter, I have concluded that the situation before us, where the House is left with two versions of events, is one that merits further consideration by an appropriate committee, if only to clear the air." End of quote. At the same time, or the same motivation to clear the air also inspired another prima facie finding by the chair in March 9th of 2011, as well as the 2014 case, as I cited. Now, while the present circumstances do not relate to Canadian participation in conflict abroad, they do relate to the justification for the invocation of the Emergencies Act, a decision which allowed Cabinet to legislate without regard to the authority of Parliament or to the usual constitutional divisions of power. A decision of this magnitude must be supported with clarity and integrity of information, just as Speaker Milliken had insisted concerning the deployment of JTF-2 soldiers in Afghanistan. Speaker, I would submit that the necessary thresholds have been made out here, allowing for you to make a prima facie finding. In order to allow for the air to be fully and properly cleared, I intend to propose referring the matter to the Procedure and House Affairs Committee so that we might get a definitive response, a report on the issue. In conclusion, Mr. Speaker, Parliament deserves to receive clear and definitive answers to questions. It must be entitled to the truth. On a matter about sidelining Parliament's own legislative and constitutional authority, the stakes are even higher. That is why I urge you to find a prima facie case of privilege in relation to the member for Eglinton Lawrence in his testimony to the Special Joint Committee on the Declaration of Emergency, for which I am prepared to move an appropriate motion. Thank you, Mr. Speaker.
Thank you, honourable member, and we're going to see if there's any input on this particular privilege motion. The honourable Parliamentary Secretary, Government House Leader.
Yes, thank you, Mr. Speaker. We'll have to review the matter in terms of the way in which it was presented and possibly come back to the House. It might take me an hour or so to respond to it in great depth, Mr. Speaker, but I'll do my best at trying to get back if there's a need to in the not too distant future.
Honourable for Brantford Brant has a question of privilege, if I remember correctly.
That's correct, Madam Speaker. Thank you. I'm rising further to the notice which I provided to the Chair under Standing Order 48 concerning the third and final report of the Special Joint Committee on the Declaration of Emergency, which was tabled in the House of Commons earlier today. In brief, on May 31st, 2022, the committee adopted an order for the production of several unredacted documents related to the government's declaration of a public order emergency in February of 2022, as well as the regulations and orders which were imposed in relation to it. The committee was particularly concerned with receiving and specifically ordered the production of a copy of the government's legal opinion for invoking the Emergencies Act. As outlined in the report, the then Deputy Minister of Justice and Deputy Attorney General of Canada wrote to the committee refusing to produce the legal opinion. While the material facts are outlined in the third report's Chapter 10, aptly titled Access to Information and Documents, I will recap the essential points for the benefit of those who aren't familiar with this particular saga, followed by citing pertinent authorities. In establishing the Special Joint Committee, the House conferred upon it, among other authorities, the power to send for persons, papers, and records. I would refer the Chair to subparagraph sub M, sub Roman numeral 2 of the motion adopted on March the 2nd, 2022, found at pages 471 to 473 and 480 to 484 of that day's journals. The Senate conferred the identical authority on the committee in subparagraph L, sub Roman numeral 2 of the motion, which it adopted on March the 3rd, 2022, as recorded in a message which this House received and published at pages 487 to 490 of the journals for that day. This being the first ever invocation of the Emergencies Act, the mandate to be pursued by the Parliamentary Review Committee required by law to be appointed was something to be settled. As mentioned in the 8th paragraph of Chapter 2 of the third report, the committee adopted a motion which, amongst other things, articulated the scope of the study it would initially pursue. The mandate included, quote, the options that the Government of Canada utilized during the invocation of the Emergencies Act, and in the, quote, study of each option, the necessity, implementation, and impact of that option, end of quote. Seized with the House's authority to compel the production of documents, the committee sought to do just that with a view to discharging the mandate which it had defined. As the committee explains in the 10th report of Chapter 10 of the third report, quote, the committee also learned that an internal federal government legal opinion had been drafted to determine whether invoking the Emergencies Act was justified under the circumstances, but the committee was unable to obtain a copy given that solicitor-client privilege was invoked. End of quote. We have since come to know, thanks to the Access to Information system, that it is a 10-page opinion and forms tab C of the Clerk of the Privy Council's February 14, 2022 memorandum to the Prime Minister to secure his formal approval for invoking the Emergencies Act. The committee elaborated on this matter later in Chapter 10, beginning with the 15th paragraph. Quote, it is worth noting that on May 31st, 2022, the committee adopted a motion that an order do issue for all security assessments and legal opinions which the government relied upon in determining that the various thresholds under the Emergencies Act had been met and that the temporary measures exercised under the Act were consistent with the Charter, end of quote. For the benefit of the Chair and the House, Madam Speaker, this is the full text of the order which the committee had adopted. Quote, that an order do issue for all security assessments and legal opinions which the government relied upon in determining that A, the threshold of threats to the security of Canada as defined by Section 2 of the Canadian Security Intelligence Service Act, required by Section 16 of the Emergencies Act, had been met. B, the thresholds required by paragraphs 3 sub A or sub B of the Emergencies Act concerning a national emergency had been met. C, the situation could not be effectively dealt with under any other law of Canada as required by Section 3 of the Emergencies Act. D, the emergency measures regulations were compliant with the Canadian Charter of Rights and Freedoms, including the analysis relied upon by the Minister of Justice in discharging his responsibilities under Section 4 sub 1 of the Department of Justice Act, and E, the Emergency Economic Measures Order was compliant with the Canadian Charter of Rights and Freedoms, including the analysis relied upon by the Minister of Justice in discharging his responsibilities under Section 4 sub 1 of the Department of Justice Act, provided that F, these documents shall be deposited with the committee in both official languages within 1 month of the adoption of this order, end of quote. Referring back to the Special Joint Committee's third report, the 16th paragraph of Chapter 10 described what happened next. Quote, on or around June 29, 2022, a letter in response to the committee's document production order was sent by Francois Daigle of the Department of Justice, in which he writes that, quote, upon full consideration, it is our department's determination that all legal opinions in our holdings that would be responsive to the committee's orders are subject to solicitor-client privilege, end of quote. In his letter, he also states the following: although other countries may have occasionally departed from this rule, in Canada, it is solely within the discretion of the Government of Canada and its ministers to waive solicitor-client privilege in respect of legal advice provided to the Crown. For reasons of principle and practice, this rarely occurs, and the general rule remains that such advice will normally be withheld from committees of Parliament, subject to such ministerial discretion and consideration of public policy. It is worth mentioning that this letter sets out the grounds for refusal only as they pertain to information protected by solicitor-client privilege, but not by cabinet confidence, end of quote. Elsewhere in Mr. Daigle's letter, found on the committee's website, he wrote bluntly, and I quote, I confirm that I'm unable to produce legal opinions as sought in the committee's order, end of quote. Chapter 10 then recounts several other instances of the committee being stonewalled by government departments claiming various reasons for not complying with the May 31st, 2022 document production order. For the sake of brevity, I will jump ahead to the 29th paragraph, and I quote, in the 2 years following the invocation of the Emergencies Act, the committee recalled some federal witnesses, particularly to obtain answers regarding its multiple requests for access to evidence, including the legal opinion the government relied on before resorting to the act. In February 2024, the current Minister of Justice reasserted the government's position that the legal advice in question was protected by solicitor-client privilege, which benefits the Government of Canada, the client in this case, end of quote. It is also worth mentioning that the 14th paragraph of Chapter 10, which notes the committee using a written questioning procedure which it deployed to gather evidence more efficiently, was further stonewalled by the then National Security and Intelligence Advisor to the Prime Minister, Jody Thomas, about the legal opinion. In December 28, 2022, she wrote to the committee, quote, due to solicitor-client privilege, I respectfully decline to answer this question, end of quote. That procedure is described in the Special Joint Committee's minutes for September 22nd, 2022, and again I quote, that the committee send to each individual organization who appears as a witness written questions submitted by the members of the committee for response, end quote, and there follows a series of details about the procedure. Back to Chapter 10 of the third report, in the 32nd paragraph, the committee summed up its position, and this, Madam Speaker, is a critical point. Quote, in light of the proceeding, The committee is concerned that it did not have access to all the information and all the documents that the federal government relied on to invoke the Emergencies Act and the related special temporary measures, in part due to the various types of privileges invoked by many of the witnesses." End of quote. In adopting its order on May 31st, 2022, the committee was exercising its authority, which is described at page 983 of the House of Commons Procedure and Practice, 3rd edition, as follows. Quote, "The standing orders do not delimit the power to order the production of papers and records. The result is a broad, absolute power that on the surface appears to be without restriction. There is no limit on the types of papers likely to be requested. The only prerequisite is that the papers exist in hard copy or electronic format, and that they are located in Canada. They can be papers originating from or in the possession of governments, or papers the authors or owners of which are from the private sector or civil society, such as individuals, associations, organizations, etc. In practice, standing committees may encounter situations where the authors of or officials responsible for papers refuse to provide them or are willing to provide them only after certain portions have been removed. Public servants and the ministers may sometimes invoke their obligations under certain legislation to justify their position. Committees of the United Kingdom House of Commons exercise the same powers with the same unlimited scope. Quote, "There is no restriction on the power of committees to require the production of papers by private bodies or individuals, provided that such papers are relevant to the committee's work as defined by its order of reference. Select committees have formally ordered papers to be produced by the chairman of a nationalized industry and a private society. Solicitors have been ordered to produce papers relating to a client, and a statutory regulator has been ordered to produce papers whose release was otherwise subject to statutory restriction. In recent years, there has been a very high-profile instance of the UK House of Commons insisting on the production of government legal opinions when, amidst the Brexit debates on November 13, 2018, it adopted a motion requiring the production of, quote, "any legal advice in full, including that provided by the Attorney General on the proposed withdrawal agreement on the terms of the UK's departure from the European Union, including the Northern Ireland backstop and framework for a future relationship between the UK and the European Union," end of quote. On December 3rd, 2018, the Attorney General of England and Wales presented to Parliament a command paper which purported to describe the overall legal effect of the EU withdrawal agreement on November 25, 2018. On the same day he made a statement to the House, neither the command paper nor the statement made reference to the resolution of November 13, 2018, and the command paper did not purport to be a return to the resolution of the House. Later that day, after representatives of 5 opposition parties alleged the government had not produced the documents required, Mr. Speaker Burkow ruled that there was a prima facie contempt at column 625 of the official report. Subsequently, the UK House of Commons on December 4, 2018 adopted the following motion, quote, that this House finds ministers in contempt for their failure to comply with the requirements of the motion for return passed on November 13, 2018, to publish the final and full legal advice provided by the Attorney General to the Cabinet concerning the EU withdrawal agreement and the framework for the future relationship and orders its immediate production, end of quote. In response, the UK government produced a complete, unredacted copy of the Attorney General's legal advice the very next day. The Attorney General later said that he had complied with the second order of the House, quote, out of respect of the House's constitutional position, end of quote, as reported at paragraph 68 of the UK House of Commons Procedure Committee's May 2019 report on the power to send for papers. A fuller description of these events was detailed in the question of privilege raised by the House Leader of the official opposition here in Canada on September 16, 2024, concerning Sustainable Development Technology Canada documents. And I adopt his comments for my own arguments for the proposition that the power to send for papers is superior to solicitor-client privilege. Our own Speaker Milliken held in his landmark decision on Afghan detainee documents on April 27, 2010, at page 2043 of the debates, quote, it is the view of the Chair that accepting an unconditional authority of the Executive to censor the information provided to Parliament would in fact jeopardize the very separation of powers that is purported to lie at the heart of our parliamentary system and the independence of its constituent parts. Furthermore, it risks diminishing the inherent privileges of the House and its members, which have been earned and must be safeguarded. As has been noted earlier, procedural authorities are categorical in repeatedly asserting the powers of the House in ordering the production of documents. No exceptions are made for any category of government documents, even those related to national security. Therefore, the Chair must conclude that it is perfectly within the existing privileges of the House to order production of the documents in question, end of quote. We would do well to recall that the Declaration of Emergency Committee's order concerned the legal opinion which was relied upon to justify the invocation of the Emergencies Act, a decision which allowed Cabinet to legislate without regard to the authority of Parliament or to the usual constitutional division of powers. In a March 9, 2011 ruling, Mr. Speaker Milliken cited page 281 of Sir John Burnow's Parliamentary Procedure and Practice in the Dominion of Canada, 4th edition, quote, but it must be remembered that under all circumstances, it is for the House to consider whether the reasons given for refusing the information are sufficient, the right of Parliament to obtain every possible information on public questions is undoubted, and the circumstances must be exceptional, and the reasons very cogent, when it cannot be once laid before the Houses, end of quote. From there, the chair added at page 8841 of the debates, quote, "It may be that valid reasons exist. That is not for the chair to judge. A committee empowered to investigate the matter might, but the chair is ill-equipped to do so. However, there is no doubt that in order to produce documents is not being fully complied with. And this is a serious matter that goes to the heart of the House's undoubted role in holding the government to account." End of quote. In the present case, Madam Speaker, the declaration of emergency committee has put this House, both Houses, actually on notice that, quote, "The committee is concerned that it did not have access to all the information and documents that the federal government relied on to invoke the Emergencies Act and the related special temporary measures," end of quote. Before concluding, I wish to address briefly Ms. Thomas's failure to answer the committee's written question. Page 1078 of Boss and Gagnon reminds us that, quote, "There are no specific rules governing the nature of questions which may be put to witnesses appearing before committees, beyond the general requirement of relevance to the issue before the committee. Witnesses must answer all question which the committee puts to them. If the committee agrees that the question be put to the witness is obliged to reply. The actions of a witness who refuses to answer questions may be reported to the House." End of quote. This is what has now happened here, Madam Speaker, and I would submit that it contributes to the overall concern about the government denying the Special Joint Committee the information which it sought. Finally, Madam Speaker, I will turn to the remedy which I would propose, namely to have the House order the production of the documents in question. This is, I would submit, a proper remedy in the present case. Firstly, Boston Gagnon discusses at page 138 and 987 the scenario where a committee report to the House on a case of disobedience to a document production order, which I note would be a contempt, may be addressed by the House adopting its own order for the production of documents. Indeed, the 2021 case involving the so-called Winnipeg lab documents saw this House, after its first production order was refused, order the President of the Public Health Agency of Canada attend the bar of the House for, among other things, the purpose of turning over the documents which had not been provided. This was, in turn, modeled on precedent cases which Boss and Gagnon describe at pages 131 and 132. In fact, the order paper is currently seized with a privilege motion concerning a similar remedy proposed in relation to Stephen Anderson, who did not turn over documents required by the Standing Committee on Access to Information, Privacy and Ethics concerning the infamous so-called Other Randy. Moreover, Madam Speaker, I would submit that your own September 26, 2024 ruling on the Sustainable Development Technology Canada documents at page 25959 of the debates speaks to the usual admissibility of such a motion when the defied order is of an ordinary character, like that which I would submit the Special Joint Committee had adopted. Quote, the members who intervened on this question used words such as unusual, novel, and unprecedented to describe this particular production order. The Chair agrees with those characterizations. It is indeed unusual, novel, and unprecedented for the House to order documents, not for its own purposes, but for a third party. Before insisting on the production of documents, as the opposition House Leader proposes to do, the Chair believes the House would benefit from having this matter studied further. End of quote. Unlike the SDTC documents order, Madam Speaker, there is nothing unusual about the order which the Declaration of Emergency Committee had adopted yet failed to see realized. Therefore, I would respectfully submit that a motion to insist on the production of the documents is entirely admissible should you agree that there is a prima facie contempt. In conclusion, Madam Speaker, this NDP Liberal government gave itself sweeping authority to legislate in this place of Parliament and of the provinces and refused to come clean about the legal authority for doing so. Without straying too far into debate, the Rouleau Commission heard testimony that from the former CSIS Director, David Vigneault, that the events of February 2022 did not meet the threshold that service must apply for threats to the security of Canada. The same threshold which Parliament said must be met before any public order emergency can be declared by the Cabinet. Yet Mr. Vigneault testified before the Commission that there was some special, magical, quote, separate interpretation of the threshold which he professionally applied day in and day out to justify the decision which the Prime Minister and his ministers were hell-bent on making. The fact that the Federal Court of Canada has since ruled that the government's actions in February 2022 were both illegal and unconstitutional only make it even more imperative, Madam Speaker, that there be full accountability and transparency for the Liberal Prime Minister's unilateral invocation of the sweeping legal powers which the Emergency Act conferred upon him.
That's right.
It is in this light, Madam Speaker, that I will refer you to page 141 of Derek Lee's The Power of Parliamentary Houses to Send for Persons, Papers and Records, concerning times when the House may need to compel the production of the Crown's law officers' work product. Quote, then UK Home Secretary Sir Robert Peel also acknowledged the power of the House in requiring the opinion of its legal officers. They stand in the situation of all other responsible servants of the Crown, and there can be no doubt that they are liable to have their opinion called for and their official acts revised where sufficient grounds exist in the opinion of the House for such a proceeding. An example of where the House might wish to require production, Sir Robert Peel said, if there was a suspicion that they, the law officers of the Crown, had acted under undue influence, an imputation against them of straining a point in favor of the Crown, the law officers would be justly liable to have their opinions called for and their official acts investigated. Similarly, Sir Robert Peel said, I will suppose a case where the law officers gave a wrong opinion or where there was an opinion given against which the government acted. In either of those cases, I admit the House would be justified in calling for the production of the opinion, end of quote. That is why, Madam Speaker, the Special Joint Committee worked so vigorously to obtain a copy of the infamous legal opinion, and is also probably why the government has so steadfastly refused to shed any light on this matter. That is why I urge you, Madam Speaker, to find a prima facie case of privilege in the circumstances and to permit the House to vote on ordering the production of the government's legal opinion. Thank you very much, Madam Speaker.
I want to thank the honourable member for the information that he has provided forward on this question of privilege. Certainly will review all of what he has provided and come back to the House on this.